All right, good afternoon. My name is Don Nguyen. I am a Florida bar licensed attorney, specially appointed by the City of Titusville to serve as the magistrate for today's code enforcement hearings. These public hearings are quasi-judicial in nature. While formal rules of evidence do not apply, fundamental due process will be observed. Everyone with a case today will have the opportunity to present testimony. You may also present evidence or call witnesses to testify on your behalf. Please note that there is no public comment portion during code enforcement hearings. To speak on a specified case, you must either be the respondent or a witness called to testify. Everything said today will be recorded. All testimony will be given under oath. When you are sworn in, please state your name and provide your current mailing address so we have an updated record for sending any orders. The city will present its case first. Information may be displayed on the screens and documents may be provided by the city as evidence. The city's PowerPoint presentation will also be entered into evidence unless there are any objections. After all evidence and testimony have been presented, I will make a ruling. My ruling will be reduced to writing and mailed to you. At this time, I'll swear in all witnesses. If you intend to testify for your case, please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. Thank you. You may be seated. We'll go ahead and move to the first item, which is approval of the minutes from the October 13th hearing. I did receive those in advance of today. I have reviewed them. They do appear to be accurate, so I'll just go ahead and move to approve them as drafted. We'll move ahead to the hearings part, and it looks like we're going straight to the Massey hearings. I'm going to skip ahead because it looks like we only have one respondent here, Mr. Manzo, so if you guys don't mind. Actually, that's the continued hearings, because we did continue that last month. So I'm going to skip ahead to D1 just to let Mr. Manzo get on his way. 25-44 at 2655 Ollie Drive. Officer May, you may begin.
All right. I do have a affidavit for the notice of today's hearing and a copy of the cost recovery statement for you.
Thank you.
So once again, this is the continued Massey hearing for case number 2544. Richard Manzo is the respondent, and he is here today. The violation address is 2655 Alley-Bird Drive. So notices did go out for today's continued hearing. This is the original case summary from the August 11th hearing. Case summary again from last month's. So I did receive a call on October 29, 2025 from the respondent letting us know that they had made the decision to have the container removed instead of moving forward with the shed permit. I did a reinspection last Friday night. It was still on the property. I did get a call yesterday from Mr. Manzo and about the container being removed. This is from October 10th. This was the original compliance state that was given. This is from Friday night, November 7th. And this is as of this morning. So the container has been removed from the property. So we are, it is in compliance with section 28-365 and 28-373 as the container has been removed. So we're asking that the property is placed in compliance for those two code sections, and then administrative costs, and those are incorrect.
Yeah, I was going to say, I think that's, okay.
It should be 146.
The amount here? Okay.
Yes, sir. Right. So I apologize, 146.14.
Okay, fantastic.
Were assessed in the original hearing.
All right. Attorney Manzo, how are you, sir?
Well, good afternoon, Judge. Mr. Nguyen. I'm here today as the property owner, and my son, who usually is talking to you, is not able to make it today. But we we had a little disagreement. He really feels that it's the principle of the thing, that we had the right to have that container there as a shed, and the state law provided for it, et cetera, as he told this tribunal several times. I told him that may be so, but there's comes a time when practicality sets in, and, I just don't see the worth going on. Plus, we had some unexpected medical issues come up, so we need to focus our attention on other things the next few weeks and months. So we made the decision, we did remove the container, and we're now asking that the penalties be waived by the city, and with the understanding that I would not return that container or any other container to my property without prior approval of the city, and that container is out of the city limits, so it's not an issue anymore for the city of Titusville.
So you're asking for not the penalties, because there are no penalties, but the hard costs that the city is seeking to recover, you would like to have those waived?
I am, Judge.
Okay. Is the city willing to consider that, or?
Actually, we ask that they stay assessed, as there was a considerable amount of staff time throughout the 3 months that we've had to go with this case, as well as the building department review, planning reviews. It's been a continuous process. And while even that small amount doesn't cover all the staff time, we ask that you assess the 146.14, sir.
All right, thank you. Mr. Manzo, I am appreciative and, thankful that you guys did make the decision to remove the trailer, or I'm sorry, the storage unit. These are hard costs that were incurred by the city, so I'm not really inclined to remove them. I mean, it's not that much either, it's $146. And I'm looking at the cost recovery sheet, and these are all hard costs that the city incurred, so I'm not really inclined to remove them, but I think you would have the opportunity, he would have the opportunity to appeal it if he wishes to do so, correct?
Yes, sir.
Yes. So I'm going to go ahead and place it down, or make the ruling, and follow the recommendation of the city. If you do so, decide to appeal, you guys are obviously able to do so. But I just don't see the basis for removing it, seeing that these are actual hard costs that were incurred, and the amount really isn't much. I don't see any real room there for me to reduce any there, so. Okay, I'm ready to make my ruling. I find, based on the evidence and testimony presented, that notice was properly provided to the respondent, and the respondent did appear. The evidence demonstrates that the property located at, gosh, I always lose the address, 2655 Ollie Bird Drive in Titusville, Florida, is no longer in violation. There will be no fine on the property. However, the city has incurred costs in the amount of $146.14 that will need to be paid. A certified copy of the order establishing that cost recovery will be entered and recorded in the public records. The respondent will be required to notify code enforcement or to make payment arrangements and inform the city that it has been paid. Okay?
Mr. Nguyen?
Yes, sir.
If I wanted to pay it today, am I able to?
I'm sure he is able to do so.
I wish I could tell you yes, but I don't have a way of printing the invoice for you.
Do I go to the windows here?
Downstairs.
Oh, downstairs?
Yes, sir, to the legal office. It'll be produced later today.
So I couldn't do it now?
No, sir, I've got no way of
Okay,
of
later today
printing that for
downstairs.
you.
I'll do that. All right, thank you.
Thank you. I
Okay,
appreciate it,
thank you,
sir.
Yep, thank you. And Judge, just for the record, the code enforcement people we've dealt with primarily with Miss May, but have been extremely courteous and professional during this. We just had differences as to what
Yeah.
we thought the law.
And I think you should be proud of your son. When he came up, I thought for sure he was an attorney, and the way he presented the case and everything.
I
So,
agree with you, yep. And he's a good son, too.
yeah. So, but
right,
thank you,
thank you
and
Hopefully, we won't see you again. As I said. Thank you.
have a good one. Give me 1 second. Let's get back on track. All right. Okay, we'll move back to the Massey hearing agenda. So starting with 25-49 for Walmart Stores East at 3175 Cheney Highway, Titusville, Florida, 32780.
So I have 3 exhibits to submit. The first is the affidavit notice of today's hearing. The second is a copy of the initial finding of fact and order. And then the third is the cost recovery statement in the amount of $234.19.
Thank you.
So once again, this is the Massey hearing for case number 25-41. Our respondent is Walmart Stores East LP. Our violation address is 3175 Cheney Highway. And the code section was 30-214 for the stormwater maintenance. We did have proper service for today's hearing. The case was originally heard September 8th, 2025. The respondent was ordered to correct the violation on or before October 28th of 2025. And administrative costs in the amount of $234.19 were imposed. So September 10th, 2025, the electrical permit was issued for the installation of the new retention pond aerator. On October 2nd, 2025, I completed an inspection confirming the pump, the aerator was functioning as designed. And on October 9th, the final inspection and closeout of the electrical permit was completed by the building department. And November 6th of 2025, the administrative fees were paid. So everything has been brought into compliance.
Great. I've never done an order like this before. Everything's done.
Everything
Costs
is
all
done.
paid. All right. Well, sends me off my script. I find based on the evidence and testimony presented that notice was properly provided to the respondent. They did come though, right? But
Yes, the manager did
Yeah.
come.
I guess it's
But
not
there-
really relevant. Yeah. Respondent did, I'm going to say did not appear. The evidence demonstrates that the property located at 3175 Cheney Highway, Titusville, Florida, 32780 is no longer in violation. Further, the costs of, well, the city's administrative costs have already been paid. We'll just, I guess, put that in writing. All right. That's it. We'll move on to the next one, which is the Schwerensky Trust at 1635 Bahama Street, Titusville, Florida, 32780.
So I have 2 exhibits for you. The first is the affidavit and notice of hearing for today's hearing and the cost recovery statement in the amount of $312.38. So once again, this is the Massey hearing for case 25-60. Our respondent is Schwerensky Trust. Our violation address and mailing address are the same at 1635 Bahama Street. Our 2 code sections are section 102.2 for maintenance and 505.1 for running water. So we did have proper service for today's hearing. So this case was originally heard on October 13th, 2025. There were no respondents that appeared at the meeting. They were found to be in violation of section 102.2 and 505.1 in order to correct the cited violation by restoring water service to the property no later than noon of November 7th, 2025. A fine of $50 per day per violation, to commence on November 8th and continue daily if compliance was not achieved. And admin costs in the amount of $312.38 were imposed. So on October 13th, during our hearings, we did receive a voice message from Lenani, who is the daughter and a trustee. She had conflicting notices of hearing. She had gotten the Massey hearing, so she was confused whether she should come or not. I did attempt to make return phone calls after the hearing with no return reply. As of November 7th, the house or the property had not, the water service with the city had not been reestablished. That being said, I received a phone call about 12:15 today from Lenani. I went to the property and she provided an entry into the house. I was able to verify that she has running water to the faucets and to the interior, and that hot water was available for cleaning and sanitation purposes. So, as of right now, she is in compliance with the 2 code section. She has running water via the irrigation meter. So I am asking that the property is found in compliance with section 102.2 and 505.1, and no fines be imposed. And I am asking for administrative costs. Ms. Lenani did ask them to be waived during our conversation. And I explained it would be up to you for waiving those fees.
And she knows about today's hearing?
Yes.
Okay, well, if I wasn't gonna.
She has anxiety issues and did not feel comfortable in coming. She was aware of it.
We are intimidating here, so. Okay. Well, unfortunately, same with Mr. Mans, I don't really have a basis to reduce them. And of course, if she intends to appeal, she certainly can. She has that avenue, so. I find based on the evidence and testimony presented that notice was properly provided to respondent and the respondent did not appear. The evidence demonstrates that the property located at 1635 Bahama Street, Titusville, Florida, 32780 is now in compliance. The city's administrative costs in the amount of $312.38 have not been paid and shall be imposed on the property. Certified copy of this order will be recorded in the public records. Done and ordered.
Thank you.
All right. Still you for 2564, Brian Davis? Is that you?
Yes.
Okay.
Yes,
All right. 25-64, that's 302 Willow Street, Titusville, Florida, 32780.
So I have 3 items to submit. The first one is the affidavit and notice of today's hearing. Second is the copy of the original order. And the third is the cost recovery statement in the amount of $241.94. So once again, this is our Massey hearing for case number 2564. Our respondent, Brian Kenneth Davis, is our respondent. Our violation and mailing address are the same, 302 Willow Street, Titusville, Florida. And there's one violation, section 308.2.2. We did have proper service for today's hearing. So the case was originally heard on October 13th. Our respondent did not appear at the meeting. The respondent was found in violation of 308.2.2 and ordered to correct the violation by removing the discarded appliances from the property no later than noon on November 7th, 2025. A fine in the amount of $250 per day per violation commencing on November 8th to be imposed and continue daily until it is corrected. Our administrative costs in the amount of $241.94 were imposed. So I have had no contact with the owner, and there has been no changes to the property. This is the photo from the initial hearing, September 26th. And this is from a Friday evening. Again, the location, the number of appliances have not changed. All attempts to make contact with the owner have resulted in no contact back.
The notice that you post on the door, has that notice been, is it still there? Or
No, it's removed.
So it does appear that
Yep.
someone's there? Okay.
So, and I leave my business card.
Right.
And still no. And I do have a phone number, but I've never been able to make contact through that phone number.
Okay.
So conclusions of fact, the property does remain in violation of 308.2.2. We are asking that the property is found in violation, assess the administrative costs, and impose the fine of $250 per day, commencing November 8th.
Okay. I find based on the evidence and testimony presented that notice was properly provided to the respondent and respondent did not appear. The evidence demonstrates that the property located at 302 Willow Street, Titusville, Florida, 32780 remains in violation. Specifically, multiple appliances and other equipment are on the property and have not been removed. The city has established a continuing violation of, what section is that? That is section 6-109, IPMC 308.2.2. Accordingly, a fine of $250 per day is imposed commencing November 8th, 2025, and continuing daily until the violations are corrected. Additionally, the costs of $241.94 have not been paid. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. The respondent is required to notify code enforcement once property is brought into compliance so that code enforcement can verify and confirm. Done and ordered. We'll move to our last Massey hearing, which is 25-69. This is Santiago and Gonzalez at 412 Mendel Lane, Titusville, Florida, 32796.
Good afternoon, sir.
How are you?
Still in vacation mode. Okay, I'd like to enter to you the affidavit of hearing and the cost recovery statement. It should be in here, and I forgot the amount. 136.28.
Sir, thank you, officer.
And this property is still in violation for Section 13-73, inoperable vehicles. Officer Wright, Code Officer Wright, checked it for me Friday since I was out of town. I went by again this morning at 10:35 a.m., and the vehicle is still in violation. I've had no further contact with anyone from the property. I did send the son a message on Friday, October the 24th, asking him to bring the property in compliance, and it has not been done.
They didn't appear at the initial hearing, right? No.
No, sir.
All right. Not much else to consider there, is there? I find based on the evidence and testimony presented that notice was properly provided to the respondent and the respondent did not appear. The evidence demonstrates that the property located at 412 Mendel Lane, Titusville, Florida, 32796 remains in violation. Specifically, the inoperable vehicles remain on the property, and the property is not in compliance with the previous order from October 2025. Therefore, I find that the city has established a continuing violation of sections 12-23 and section 13-23.
No, just correction, sir, just 1373.
Oh, sorry, I'm sorry, just 13-23 for the inoperative vehicles. Sorry about that. Okay. Accordingly, a fine of $100 per day is imposed commencing on November 8th, 2025, and continuing daily until the violation is corrected. Additionally, the costs in the amount of, just had it, $136.28 has not been paid. A certified copy of this order will be recorded in the public records constituting a lien on the subject property. Respondent is required to notify code enforcement once the property is brought into compliance so that code enforcement can verify and confirm. Done and ordered. All right, and I believe that concludes our Massey hearing, so we'll just move to our initial hearing for today, and this is 25-74, Bethune and Adelson at 218 Ojibwe Avenue, Titusville, Florida 32780.
I have 3 items to present to you: is a notice of hearing, notice of violation posting, affidavits, and the cost recovery for $189.11. The respondent is Shirley Bethune and Jacques Adelson, and also SunWest Mortgage Company, Inc. The violation address, 218 Ojibwe. The mail-to address is 218 Ojibwe, and since it's a registered property, also send it to the mortgage company of 18303 Gridley Road, Centeros, California. The violations are the accessory structure for the fence, 302.7 and 304.2 of the IPMC code for enclosure of the swimming pool. It also had an overgrowth of the weeds, but we abated through the city, so that's been taken care of. The initial violation was on August 6th, was given till August 20th to comply. It was mailed to and certified on the 6th as well, and the notice of hearing was also posted at City Hall and on the property on October 29th. During proactive checks for violations in the area, I found this location had a fence falling in need of repair, overgrowth of grass and weeds, and no swimming pool enclosure for an above-ground pool that was in the backyard. Notice of violation was posted and mailed to the owner. There's been no contact with the owner, but I did receive a letter from the mortgage company stating since the property is still since the property is still occupied, they're not going to correct any of the violations until they move out. Results of the inspection, other than us cutting the grass, no other action has been taken to fix the fence or make any pool enclosures. This was the initial check. You can kind of see where the fence on the side there with the garage is down and damaged, and there is a above ground pool in the backyard. There's a better shot of the reinspection. The fence is still down with the pool in the backyard. And then you can see the above ground pool there as well. With the fence still damaged. I thought I had one of it cut, but the above ground pool is still there. I don't know for sure how much water it has in it because I can't go in the backyard, but since it is in the backyard, it's an access road in the back to see the backyard, so I was still on public property to see it. The conclusions of facts: the accessory structure of the fence is falling and missing slats, and the swimming pool does not have proper protective fence or security around it. And the recommendation is the fence needs to be repaired or replaced, and the pool needs to have a proper enclosure or remove the pool. We ordered a respondent to correct the violations by December 5th. If the respondent does not comply with the fine of $100 per day per violation commencing on December 6th until the violation is corrected, and order the respondent to pay the administrative cost of $189.11 and to contact me for reinspection once it is corrected.
I'm glad the city's new attorney is here so I can ask her a question that's sort of a legal exercise. So I was confused there why the mortgage company was listed there. So I checked on that, were they on title or something like that. So it turns out the Bethune and Adelson parties have been foreclosed. The bank took title on October 9th. Certificate of title was issued on October 9th in favor of the bank. Our notice would have gone out on October 8th. So being that that's the case, do they, as the new owner, how does that work? Because they have a notice of lis pendens on the property, which I guess concluded at the time that.
Right. Well, I think the statute provides that our notice requirement is based on our PAPA, well, I have PAPA, I don't know what it is here, in West Palm Beach, but the property appraiser office, right?
Yeah.
That's what the statute has tasked us to go by.
Right.
So at the time when our notice was sent out.
Which would have been a day before the certificate of title. It would have been Adelson and Bethune.
Correct,
Yeah.
but like you said, there would have been a lis pendens, giving everyone a notice that there was a proper foreclosure action. So, of course, there's sometimes competing legal analysis. Our position would be, we're following the statute and we notice the proper, at the
Yeah.
time, who the property appraiser's office
Yeah,
has as the correct, as
Yep.
the owner. So that would be our position.
Right.
But yes, it is a good legal exercise, but our position is properly noted.
And I would say that's probably right because this is an initial hearing anyway. This is not where we're actually imposing the lien per se, right?
Well, I
So,
have to tell you this, and we'll talk as a group. Where I'm coming from, we only have one hearing.
oh, okay.
So, which is interesting that we have two hearings here.
Mm-hmm.
That is something, we can further discuss.
But-
But again,
Right.
Our position would be was properly noticed based on the
Right.
requirement of the statute,
Yeah.
which, I don't know here, do we do all four or we just do one, notice of the requirement? Or do we do, cert, regular, on the property
Property.
and city hall? Okay.
So it's on the property, and even though it's the bank that ultimately foreclosed and took title, it's still obviously buyer beware anytime you're taking title via foreclosure. So I would say they took title subject to any ongoing violation. So I tend to agree with what you're saying. The dates were just interestingly enough that let me just pose this to you. Yeah.
Yes, for sure.
All right. Okay. Anyway. All right. I've accepted and considered documentary evidence, including photos and sworn testimony relating to the matter from city staff. I find that the respondents, being Shirley Bethune, Jacques Adelson, and SunWest Property Investments LLC, which is the mortgage company. And so they are listed as a respondent, I think, in the documents that you provided to me.
Yeah, like I said,
You sent the notice
They
to
sent
them.
me a letter stating they
Okay.
received the notification and they're not going to do anything
Okay.
since the property was still occupied, and as of today, they're
Right.
still living there.
So respondent SunWest Property Investments is the owner of the property with the address of 2180 Ojibwe Avenue. I find that all required notices were provided in accordance with Chapter 163, Florida Statute and City Code, and notice was met for this hearing. Based on the evidence presented, I find that violations of sections, let me get the exact sections here. Bring back up the PowerPoint, would you?
I think the violation letter should be in that folder.
Yeah. There was one that was fixed, right? Okay, so
Yeah.
sections 6-109, I'm sorry, section 302.7 regarding accessory structures, and section 6-109 IPMC section 304.2 regarding enclosures and swimming pools exist upon the property, and respondents were given a reasonable amount of time to correct the violations, but have either failed or refused to do so. The corrective actions for these violations will be to fix the fence and install proper protective fencing or security around the swimming pool. Additionally, I find that the city has incurred costs in the amount of
189.
$189.11. Such amounts shall be included with this order. Respondents shall be given until noon on December 5th, 2025, to correct the violations. Respondents shall be responsible for notifying code enforcement of completion of such corrections, who shall then confirm the status of the violation. If respondent fails to correct the violation, a fine will be entered in the amount of $100 per day until the violation comes into compliance. Further and future violations of the same section shall be classified as a repeat violation. A certified order may be recorded in the public records of Brevard County. It is so ordered. Thank you. And I believe that takes us to the code enforcement manager's report.
No report, sir.
All right. Then I will go ahead and move to adjourn us at 1:36.
Yes, sir.